right here, I have the preliminary injunction of the GOA case versus New York State over their Constitutional Carry Improvement Act. Let's go ahead and talk about it. What is up, Wolverines, and welcome back to my little corner of the internet known as John Crump News. As you might have guessed, my name is John Crump. I'm an investigative journalist, and I keep an eye on the 2A space, including this case. If you can do me a huge favor, like, comment, and subscribe. Let me know what you think of New York's gun laws down below, and if you think GOA is going to be successful. Myself, I think they will be. I know the attorneys, and they're very, very good. Okay, let's go ahead and jump into the case. A Ukrainian immigrant, Ivan Antonyuk, Gun Owners of America, GOA, and Gun Owners Foundation, GOF, which is the nonprofit arm of GOA, has sued New York over the CCIA. The CCIA stands for the Concealed Carry Improvement Act, which is not really an improvement. It's actually a big step backwards in concealed carry law, but we'll get into that in a little bit. They sued over the new laws, and now they have filed for their preliminary injunction, and I think they're going to get it. So let's go ahead and go through the preliminary injunction and talk about what it says and who the people are. Okay, Ivan, I'm not going to try to pronounce his last name again because it's impossible, is a plaintiff in New York, and he currently has an unrestricted carry license. Licenses in New York go county by county. So a sheriff can issue you a license, a restricted license, which means you can only carry while hunting, or an unrestricted license, which means you can carry anywhere concealed. And Ivan had one of these unrestricted carry permits. So because he has one of those and the new law affects him, he has standing. So that is something that is very important to have standing. If you don't have standing, your case will get thrown out. It talks about what will happen to him when he goes out now under the new CCIA. For example, if he goes to a gas station or to get food, he would have to disarm and lock up his gun if he goes into any business not displaying a sign saying that you're allowed to carry. Under the CCIA, by default, every place is a gun-free zone unless you put up a sign saying it's not. So Ivan would have to disarm and lock up his gun in a locked box. And I'm not talking about a glove box because that does not meet the requirements under New York law. It would have to be a separate locked box. That also means that if he accidentally ventures off the street and steps on private property, he is guilty of a felony. So basically, you can become a felon on accident by just taking one step off a public road, which is really, really ridiculous because if you carry somewhere where a sign is not displayed, you are guilty of a felony under the New York law, which is kind of crazy, right? The filing also talks about the training requirements. Right now, Ivan has a unrestricted carry permit, but when he goes up to renew again, he's going to have to meet the requirements laid out under the CCIA, which means he's going to have to take a training class 5 times longer than the one he currently has, which means he's going to have to spend hundreds of dollars. Right now, I think they're charging like $400 to go through training. He's going to have to take off multiple days of work because under the CCIA, you need 16 hours of classroom and 2 hours of range time, which means you have to take off work. That is a considerable investment. And that's not even the worst thing about it. The social media aspect of the whole entire CCIA is terrible. You have to give over your social media profiles to New York. They look for something called good moral character. Basically, all they did is replace proper calls with good moral character. And you have to give over your social media profile. So basically, you're trading your First Amendment for your Second Amendment rights. The PI makes a very good point. It said if the founding fathers were to approach the British and ask for a permit to carry a firearm, and when they asked why they want to carry a firearm, the founding fathers said, because we want to declare independence and break free of you guys, what's probably going to happen is that they would get denied. So I thought that was kind of clever. That was written by Stephen Stambolier, also known as the Machine Gun Lawyer. He's a really good guy, and I should have a quote from him shortly. One of the biggest problems is it pushes people into self-censorship. If you post that you think the election was stolen or COVID-19 vaccines are bad, or if you're just on True Social and a Trump supporter, you're probably going to not be found to be of good moral character because, once again, it's all subjective. It actually says in the PI that what happens if someone gets a lot of speeding tickets in a school zone? Are they not of good moral character? It is really, really subjective, and therefore it's unconstitutional because it discriminates against people. It's like a pre-crime system, and the PI actually calls it a pre-crime system. The PI also used Governor Huckle's, whatever, I can't say her name, Huckle, quotes against her where she said that the Bruin decision was reckless and irreprehensible, senseless, and a backwards act. Well, guess what? Your CCIA is exactly what you just said. So Huckle actually admits that the whole CCIA was in response to the Bruin thing to try to get around Bruin, which is not exactly allowed. There's a couple things that you need to succeed in a preliminary injunction. One, you have to show that you can succeed on the merits of the case, and I think GOA has a very, very strong case on this. I think that they will succeed on the merits of the case, and I think the judge will see this and determine that GOA does have a very, very good shot and is likely to succeed on the merits of the case. The second one is monetary damages. If damages can be fixed by monetary means, which means cash, then you can't get a preliminary injunction. But in this case, the delay of being able to exercise your rights cannot be fulfilled by monetary damages if the case is successful. So I think the judge is going to look at both of those and determine that GOA is in the right. Can I be 100% certain? No. As I've said before, you never know what a court's going to do until it does it. So if anybody says they know exactly what the courts are going to do, they're wrong. They don't, because the courts can do some pretty oddball things. But I do like GOA chances. With the chicken farmer Rob Olson and the machine gun lawyer Stephen Stambolier on the case, I think they have a good shot to win. These are two of the top attorneys in the country, and pretty sure that they're going to win. All right, that is it for today. Check out my live channel at John Crump Live, where I do live shows, but not this week because I'm kind of on vacation, even though I'm doing a video, right? You can probably hear the kids in the background. I don't have my soundproofing up, but whatever. All right, guys, I love you very much. Stay ever vigilant. Stay ever free. Keeping the fight. I am out of here. Hey, brother-in-law Chris, do you want to come be on camera? That's a no. Wolverine's mother.